Hi there, welcome. I hope that you all are doing well. I'm Jordan Woods from the University of Arkansas, and I'll be moderating our sections panel today on the intersection of religion and children's issues that's co-sponsored by the sections on law and religion and sexual orientation and gender identity issues. We have three terrific presenters today, so I intend to keep my opening remarks and my introduction short. One quick section announcement at the beginning. We're seeking a new secretary for the Children and the Law Section Board. If you'd like to serve or know someone else who would, please send nominations to our section chair, Julie McConnell at Richmond by January 9th, 2021. And then we are going to meet virtually shortly after the AALS meeting to elect a new secretary. So I'm going to briefly introduce our speakers in the order of presentation. In terms of structure, each presenter will have up to 15 minutes to present their work. And then at the end of all three presentations, we'll have Q&A. Since we're using the chat feature for Q&A, please input any questions that you have in the chat, and I'll read those questions to the panelists. And please feel free to introduce yourself in the chat as well if you would like to. So without further ado, Jenny Chang from Vanderbilt Law School will be our first presenter. Jenny is going to present on the implications of the current pandemic on the homeschooling movement in the United States. Jenny holds a JD from Harvard Law School, a PhD in political science from the University of Michigan. Her research focuses on the political and legal treatment of children, especially adolescents, and she's written extensively about the history of the minimum voting age and the constitutionality of laws affecting young voters. At Vanderbilt, she teaches courses on education and family law. Elizabeth Katz will be our second presenter from the university, from Washington University in St. Louis School of Law. She's going to present historical research on the intersection of religion and adoption. Elizabeth is a legal historian who's an expert on family law, criminal law, and U.S. legal history, including the women's right to hold public office. She teaches first-year criminal law, family law, and a seminar on the law's treatment of race and religion in family contexts, historically and today. Immediately prior to joining Washington University School of Law, she was an inaugural fellow at Stanford Law School Center of Law and History. And then finally, Frank Cervone has agreed to be our external speaker. We're especially grateful that he's taken the time to join us. Frank serves as the executive director of Support Center for Child Advocates, the lawyer pro bono program for abused and neglected children in Philadelphia. Prior to his work at Child Advocates, Frank was a staff attorney at Delaware County Legal Assistance Association and an adjunct clinical professor at Villanova University School of Law, where he instructed law students in domestic abuse and child support litigation. And he previously served as counsel for St. Gabriel's System, an agency providing treatment services for juvenile offenders. We're especially excited to hear the work that Frank, as well as the Support Center for Child Advocates, did in the Fulton case that the U.S. Supreme Court recently heard oral arguments on. As many of you are likely aware, that case involves the city of Philadelphia and whether Catholic Social Services, a private faith-based agency that contracts with the city and refuses to work with same-sex couples on religious grounds, must comply with the city's non-discrimination policy. So thank you to all of our presenters, and thank you in the audience for coming. I now turn the floor over to Jenny for our first presentation of the day.
Hi, everyone. Thank you, Jordan, for that lovely introduction. Thank you for organizing this panel. Thank you to all of you out there who are watching us. We're looking forward to hearing your questions. So what I'm going to talk today about is my ongoing project about homeschooling in America. I started this project before the pandemic, but it's certainly taken on new dimensions with the events of the last year. And so what I want to argue today, which is a little bit in tension perhaps with the agenda of our panel, is that we should stop thinking about homeschooling as a largely religious, specifically conservative Christian phenomenon. A lot of homeschoolers, perhaps the majority, we're not quite sure, are still, as they were before, conservative, white, evangelical Christians. But the nature of the practice, the meaning of the word homeschooler, the institutional players in the landscape have changed. And we have a sort of new framework, new landscape, and we have some new problems. And our current regulatory system, which is a product of an earlier era, is entirely inadequate, sort of non-responsive to the problems that we have today, problems that have only been supercharged by the events of the last year. So I'm going to start by talking for a few minutes about some history. For those of you who aren't familiar, I'm going to talk about how the current legal framework around homeschooling is a product of a time when homeschooling was, in fact, substantially, although never exclusively, a white conservative Christian phenomenon, and how this is reflected in our legal apparatus. Then I'm going to talk about how in the last 10 to 15 years, really the last decade, things have changed significantly. The sort of who's homeschooling, why they're homeschooling, especially how they're homeschooling has really changed quite a bit. And we have some new challenges. And the existing regulatory system is simply unrelated to these problems and not helpful. And so I'll conclude with a few thoughts on how we might change our approach. So the legal framework for homeschooling in the United States dates from a time when homeschooling was, in fact, closely intertwined with conservative white Christian politics and culture. So scholars generally trace the modern homeschooling movement in the United States to the 60s and 70s, and actually, and as a left-wing countercultural phenomenon, with folks like John Holt arguing that the post-war educational system was just designed to turn out dutiful worker bees, and it was too industrial, too corporate, and that parents should keep their children from turning into automatons by keeping them home and educating them at home. The legal status of homeschooling at the time was unclear. So every state, as I'm sure all of you know, has a compulsory education statute. And these statutes are enforced generally through child protection laws, which define educational neglect or not fulfilling one's obligation to educate your children sort of as illegal under actionable under child protective laws. And at the time, it wasn't clear in a lot of states whether, in fact, these homeschooling families were breaking the law. And in fact, magazines and other publications of the time warned parents, not to take their children to the park during school days, school times. Don't tell your family members that you're homeschooling. There was a lot of concern about the legality of it. And in fact, homeschooling had a sort of transgressive, kind of lent its sort of edgy countercultural quality to it. And its ambiguous legal status was part of that. But this countercultural thread was picked up and reframed in the 80s and 90s by conservative white Protestant Christians as part of the broader evangelical Christian cultural and political revival of the time. Except instead of being concerned that public schools were cranking out dutiful workers for the military-industrial complex, these parents were concerned that that public schools were teaching their children anti-Christian, corrupt, morally bankrupt values, teaching them things like evolution. So in addition to bringing a lot of new homeschoolers and homeschooling families into the movement, a lot of new institutional and organizational players sprung up at the time. Advocacy groups, social organizations, curriculum providers, state support groups. And the Christian legal advocacy groups essentially designed the regulatory framework that still governs homeschooling today. So these groups were both homeschool specific, like the Homeschool Legal Defense Association, and other more general Christian right legal and political organizations. And what they did was they lobbied state legislatures to make homeschooling explicitly legal, and furthermore, to not regulate it very much at all. And the arguments they made sounded a lot like the arguments in Yoder. I'm sure you're all familiar with the Wisconsin v. Yoder case. And they argued this was a matter of religious freedom, that in order to educate their children, Christian parents to educate their children in their religion needed to be able to keep them out of the corrupting public schools and educate them at home. Opponents mostly came from school teachers unions, some child advocates, similarly voice the claims that some of the arguments that we know about from Yoder, the dangers of isolating children, lack of exposure to diverse peers and ideas, the dangers of possibly teaching extremist views. But as a common political dynamic, the opponents were considerably more diffuse in their opposition than the proponents were in their advocacy. And ultimately, this movement was extremely successful in state legislative houses. So the rules that we have today date from this time. So Homeschooling is, in fact, legal in all 50 states. All states have statutes that explicitly permit homeschooling as a way to fulfill the compulsory education requirement. And in fact, it is minimally regulated. In some states, it's not regulated at all. Other states have some kinds of light regulation. Parents have to send in an annual notice of intent. In Pennsylvania, parents have to have their children's portfolio reviewed annually. Some states, parents have to have their children take state standardized tests a couple of times. But furthermore, there's often carve-outs. Even in states that have some regulation, there's also carve-outs for Christian-affiliated homeschoolers. So here in Tennessee, where I am, there's sort of moderate, mild regulation. Annual notice of intent, parents need to send in some attendance materials, and they have to have their children tested. I think it's 5th, 7th, and 9th grade. But if you are a homeschooling parent and you affiliate with a church-related school, then none of those applies. None of those rules require, and your children do not need to be tested or accountable in any way. And of those church-related schools in Tennessee that are allowed to use to get out of these other rules, all but one of them is explicitly Christian. Now, it's interesting to note that simultaneously, these advocates filed a number of cases in federal courts, generally sort of hybrid claims combining First Amendment free exercise with 14th Amendment due process parental rights, effectively trying to extend Yoder to homeschooling. And these cases were unsuccessful. There were a couple of victories at the district court level, but in general, these arguments really didn't go very far. There are a couple of state court cases that had to do with interpreting state compulsory education requirements, most notably in Texas, that ultimately wound up giving homeschoolers some legal protection. But really, these were legislative victories rather than court victories. And in fact, it's perhaps because these advocates were so successful in the legislatures that there has wound up being very little impact litigation regarding homeschooling. When homeschooling comes up in a court situation, it's generally in the context of divorce. And one interesting thing is that the preeminent conservative Christian legal organization at the time, the Homeschool Legal Defense Association, which I mentioned before, has never been willing to take on divorce cases. So this issue just hasn't come up much in the courts. There were some efforts by HSLDA and others to push for a parental rights amendment in the late 90s and early 2000s, but it never really went anywhere, I think in large part because people who would be pushing for it felt that they had a lot of freedom under the existing statutory system. And so just emphasizing here that despite this whole framework being so infused with religious considerations, when we're talking about homeschooling law, we're talking about statutory law, not constitutional law. So the last 10 to 15 years, though, there has been a real sea change. And just overall, religion has become far less salient in the homeschooling world. So there has been an explosion of institutions and programs that bridge public and homeschooling. State virtual schools, homeschool charter schools, part-time public school enrollment, dual enrollment in community colleges. So some of this is, I think, simply because of the development of the internet, but it's also, I think, closely related to the school choice movement, which has led to a lot of these sort of alternative education frameworks being created. It's a little unclear whether the homeschooler population has actually become significantly more diverse in terms of religion and race. It's hard to tell. Obviously, homeschooling, because it's so labor intensive on the parts of parents, is always going to be confined to a certain economic level. And there have been studies that have suggested that there remains a high percentage of conservative evangelical Christians who identify as homeschoolers. A high percentage of homeschoolers continue to identify as conservative evangelical Christians. However, there's also been some research suggesting that these same parents are less likely to cite religion as their main reason for homeschooling than they were, say, 20 years ago. That parents, even religious parents, are more likely to say they're homeschooling now because their child needs more individual attention, or is having academic issues, is having bullying, social problems. So even among parents who identify as religious, it's arguably that they think of their homeschooling as less of a religious practice than homeschoolers 30 years ago did. The word homeschooling has also started to be used come to be used much more broadly. And in particular, in the last 10 years, it's become quite common for parents whose children are doing online school, whether it's independent online school, parent purchases the program, or does it through a state or other virtual school program, describing themselves as homeschoolers, showing up at homeschool groups, participating in homeschool activities, identifying as homeschoolers. I should note here that this has caused quite a lot of tension in long-standing groups. I interviewed one woman who said that that the used to be that there were the big difference in homeschool social groups with were you a secular homeschooler or were you a religious homeschooler? Were you a Christian homeschooler or were you not a Christian homeschooler? And social groups are frequently organized around that fault line. She said the big thing now is are you an online homeschooler or are you educating your children yourself? Are you a corporate homeschooler or are you a mission-driven homeschooler? So obviously the pandemic has broken this wide open. You can see in the media, so now homeschooling is very much commonly used to mean state virtual school or local virtual school, which again is an issue that has come up in interviews I've done with longtime homeschool advocates who worry about homeschooling being defined as public school online. So, but what we have some new problems. And to my mind, for anyone concerned about the quality of education among homeschoolers, the issue is really less what curriculum people are choosing and the science coverage, and more the poor quality of most of these online learning programs. They're dominated by a few big players who serve both public school and independent homeschoolers. There's just different pricing for them, and they are overwhelmingly mediocre. And in fact, I would say that the incentives here actually push down the quality of these programs. There's also some bureaucratic roadblocks for parents who want to go back and forth between homeschooling and public school. And I think many of these date from an era in which, again, homeschooling was viewed to be more of a sort of separate ideological practice rather than something that a parent might do for a few years while a child is having, say, difficulty in middle school. And so there are a lot of issues, particularly with high school. A lot of high school districts won't take homeschool credits for any part of high school. So high school winds up being an all or nothing thing. If you get to the end of homeschooling, you're a ninth grader and decide, actually, I really do not want to do high school math at home, it's not uncommon for the public school to say, well, your child's going to have to repeat the ninth grade if we take them back. And finally, because homeschooling has become more mainstream and less identified as a strictly religious practice or predominantly a religious practice, over the last decade, there has been more and more anecdotal reports of children with disabilities being pushed out of public schools, with public school principals and teachers who have a legal obligation to accommodate, saying, we'd love to have your child here. I'm just not sure we can do all of this. Have you thought about homeschooling? And so increasingly I've come to meet, I did an interview with a woman in New York City whose son has severe allergies, and she very much did not want to be homeschooling her child, but the school had said, I just don't know if we can keep him safe. Have you thought about homeschooling? So the point I want to make is that the existing regulatory system that we have cannot even begin to address any of this. It's premised on the idea that homeschoolers are a small, idiosyncratic group of people who mainly want to do their own thing. To the extent that there are justifications for letting them do their own thing, they're pluralistic, right? And to the extent that there's any regulation, the goal of that regulation is to try to prevent them from simply going completely off the rails, right? To try to maintain some minimum level of academic and other accountability for their children. But I would suggest that these new problems are really different in quality, and that they demand not regulations focused on individual families, but much more policy and administrative involvement, particularly with these sort of interstitial institutions that I was talking about before, these institutions that combine elements of public schooling and homeschooling. For example, given that so many students are using online education, I would say we should be focused on developing high quality or at least adequate quality public programs that align with state academic standards and state university requirements. To my mind, if we want to pay any attention to the educational quality of homeschoolers, that would be the most important thing. So obviously the pandemic has been a seismic event around the world, and it's been an absolutely catastrophic event on so many different axes. From the perspective of what I've been talking about today, it's certainly interesting that now millions of Americans, both adults and children, have now had some experience with homeschooling on some definition, whether it's a more traditional definition or whether it's online school at home. And we don't really know what's going to happen afterwards, right? We think that some folks it seems possible that some people who have been doing what I'm going to say sort of traditional homeschooling, non-online homeschooling may stick with it. It seems entirely probable that plenty of parents will be, we're never doing this again. And in terms of online public schooling, I've been struck in talking to people about the expectations that a substantial minority of students may continue with it. So here in Nashville, I interviewed one school board member who suggested that they expect as many as 20% of Nashville public school students to continue with online public school after the pandemic is over. And I should note here that Nashville, the Metro Nashville public school population is at least 70% free and reduced lunch. So I was surprised to hear this, but she said no. There are parents who are there's quite a number of parents who are happy not having their children in school, and they expect them to continue with virtual school after the pandemic ends. So eventually, God willing, this will end and the dust will settle. And I think that we will have a new opportunity to take a look at this one corner of the education world and think in new ways and fresh ways how we might make it better. Thank you so much. I'm really looking forward to hearing the other speakers and everyone's questions.
Great. Thank you so much, Jenny. Our second speaker is Elizabeth Katz from Washington University in St. Louis School of Law. So Elizabeth, the floor is yours.
Great. Well, thank you so much, Jordan, for organizing the panel. I'm really pleased to have the opportunity to discuss the intersection of religion and children's issues with my co-panelists. We're all coming from different perspectives, which I think will make our discussion really interesting. My remarks focus on Fulton v. Philadelphia from a legal history perspective. So in my comments, I'm going to emphasize the ways history mattered in the briefs and oral argument. And then I'm going to turn to my own research to explore some of the historical context that I think has been missing from discussion in and about the case. So as many of you likely know, the U.S. Supreme Court heard oral argument in Fulton v. Philadelphia on November 4th, which now feels like a really long time ago with everything that has happened recently. The central issue in Fulton is whether a faith-based foster care agency, here Catholic Social Services, can decline to screen and certify would-be foster parents who are in same-sex marriages, even though the agency is acting pursuant to a state license and receiving public funding. The foster care agency argues that it's a violation of their First Amendment rights to be required to choose between their religious beliefs about marriage and their ability to continue providing foster care services. There have been several similar cases in other states also involving adoption, and it's likely this issue will only grow because several states have recently passed statutes to exempt religious child placement agencies from anti-discrimination laws. Now, moving into the briefs and oral argument in Fulton, history has been a significant component. Amicus briefs filed in favor of the agency argue that the Catholic Church has been providing services to needy children for nearly 2,000 years. That's a quote from one of the briefs. Or some are more limited and just focus on American history and also emphasize Philadelphia history. The intended takeaway is that religious groups have been providing child welfare services in line with their beliefs without incident for hundreds of years. So why should they have to stop now just because there's a new kind of family form that violates their religious beliefs? There were two amicus briefs filed on the other side that had meaningful historical engagement. One, unsurprisingly, was filed by historians of child welfare. Their main point was that private child welfare agencies, including faith-based agencies, have always been regulated by the government to some extent. Starting again with colonial America and moving forward to today, the historians argue that the longstanding public-private partnership in this space has always involved oversight, including for the purpose of combating discrimination that left some children without adequate care. The other amicus brief that used history to support the city was filed by scholars of Indian law. Their main argument was that white Christian groups actively collaborated in the mistreatment of Indian children who were removed from their homes in an attempt to assimilate them into white Christian culture. In other words, religious group involvement in child welfare and placement has been harmful to at least some minority groups. History was cited during the Fulton oral argument as well. The lawyer for Catholic Social Services referenced history the most. She repeatedly emphasized that religious groups have been doing similar kind of work in Philadelphia for 2 centuries. One of the many mentions of 2 centuries was directly set up by Justice Gorsuch, who asked, "How long has Catholic Services been engaged in this activity?" The advocate also said, "I think the history here is important." History was not a major part of the argument on the other side, but the lawyer for the city did critique CSS's historical arguments. He said, "She kept on saying we've been doing this for 2 centuries. Private entities have never done this because whatever those entities did before, they never selected who cares for kids in city custody, applying state criteria." Now, turning to my own research, I want to suggest there's a more complicated history of religious group involvement in child welfare services that wasn't fully acknowledged in the Fulton arguments because it's not very well known. The more nuanced take is that religious group involvement, while certainly offering real benefits, has routinely caused religion-based controversy and resulted in the exclusion of vulnerable religious and racial minority children, as well as adults who could have served as foster or adoptive parents. It's very difficult to cover centuries of history within my allotted time, so I'm going to try to provide an overview that builds on existing scholarship by focusing more on religion and extending later in time. In early American history, foster care and adoption, as we understand them now, did not exist. Instead, orphaned and dependent children were primarily placed in apprenticeships, indentures, and poorhouses, all overseen by public officials. There were some orphanages available as well, as some of the Fulton briefs note, and many of these were run by religious groups. However, most children in need of care did not go to institutions until the mid to late 19th century, depending on the location. In the second half of the 19th century, orphanages became more popular because of new ideas about child development, a shift away from child labor, and some other social and economic changes. Notably, orphanages were not just for true orphans in this period. They were for any children whose parents could not afford to maintain them. Parents sometimes chose to use orphanages as temporary safety nets. Religious groups were active in running orphanages, especially in cities where there were significant Catholic and Jewish immigrant populations. Catholics in particular, and Jews to a lesser extent, feared that supposedly secular institutions or different child welfare agencies were actually covers for Protestant proselytizing. In many states, religious groups protected their interests in children's religion by securing statutes that required that children be sent to institutions run by people of the same religious faith. These religion matching statutes were not new, but they were broadened, strengthened, and spread around the end of the 1800s into the early 1900s. The combination of the turn to orphanages and passage of religion matching statutes seemed, in the view of some charity leaders and politicians, to create perverse incentives. Many observed that Catholic institutions took in disproportionate numbers of children and held them for longer periods than orphanages run by other groups. This seemed to place a drain on public resources and to arguably not be in the best interest of children, leading to tensions along religious lines. Religion matching was also problematic because it meant there were hardly any resources available for children who did not belong to one of the major religious groups. And as more African Americans migrated to northern cities in the first decades of the 20th century, Religious groups at best segregated them and more commonly failed to serve them at all. Though orphanages continued to play a major role in child welfare over the following decades, there was also an increasing belief that children belonged with their families. One of the key moments in this shift was the White House Conference on Children held in 1909. Many charity reformers and other attendees were persuaded that home care, rather than institutional care, was best for children. Where it wasn't possible to keep families together, home-like settings were the next best option. So this is when foster care started to seem increasingly attractive. Tellingly, the 1909 conference was symbolically presided over by a Protestant, a Catholic, and a Jew. It was clear to everyone that religious groups would continue to be involved, now increasingly focused on identifying foster families in the same religious faith. Religion matching laws were accordingly extended to cover foster care as well. Some of the same problems that surfaced in institutional care reappeared here: perverse financial incentives and inadequate care for minority groups. Throughout the developments I've been describing, adoption was technically an option, but it only became a significant part of the child welfare scene starting in the 1920s. Adoption was the domain of social workers, and social workers believed that the key to successful adoption was matching children to adults by characteristics including religion, appearance, intelligence, and temperament. Of these factors, only matching by religion, and later on race, was so important that it was enshrined in law. Common statutory language stated that a child's religion should be the same as the adoptive parents' to the extent practicable. This raised the question of when an adoption petition should be denied on the basis of a religion mismatch. When was religion matching not practicable? There were some cases involving this statutory language in the first half of the 20th century, but the issue really exploded in the 1950s, coinciding with a huge increase in the number of adoptions by non-relatives. This conflict mostly pitted Jews against Catholics for both practical and philosophical reasons, and it prompted significant legislative lobbying and litigation that reached several state Supreme Courts. First, the practical. There was a significant supply-demand imbalance in the availability of healthy white infants, seen at the time as the most desirable, along religious lines. In short, because of different perspectives on birth control, unwed motherhood, and other social issues, there were almost no babies born to Jewish women who were available for adoption, but there were many born to Catholic women who needed adoptive homes. Thus, Jews, and to a lesser extent, Protestants, mixed religion couples, and other minority religious couples had little to no chance of adopting unless they could adopt children born to Catholic mothers. This meant that laws that mandated or strongly encouraged religion matching effectively excluded some groups from adopting at all. This could also mean that Catholic-born children faced longer periods in institutions or foster care than if they could have been adopted across religious lines. Second, there were legal reasons that Jewish civil rights lawyers and others opposed religion matching laws. While Jewish civil rights lawyers and their allies thought birth mothers' choice of religion should be respected, they were deeply troubled by situations where the birth mother expressed no preference on religion or even specifically approved a Jewish couple, and the court refused to permit the adoption to go through solely on the basis of religion. They argued that courts' refusal to allow cross-religion adoption was essentially giving legal weight to Catholic baptism and therefore violated the First Amendment. The American Jewish Congress was particularly active in this space, as it was in many First Amendment issues in this time period. In the adoption context, the AJC represented parents, filed amicus briefs, or advised behind the scenes in around a dozen cases that received nationwide publicity. Several of these cases involved tragic stories of children being removed from the homes of the only parents they had ever known solely because their religions did not match. The nation was captivated, leading to congressional inquiries and other high-profile developments. The American Jewish Congress tried unsuccessfully to get the Supreme Court to grant cert in several of these cases, extending into the 1960s. By the 1970s, this issue was still heated and had evolved into questioning the near exclusion of atheists and mixed religion couples from adopting. Over time, the strength of religious considerations in adoptions and foster care has lessened, both through statutory changes and case law. Yet many states still have versions of religion matching statutes on the books. And in practice, religion matching may still occur when a faith-based agency dominates a particular location and excludes everyone that doesn't subscribe to their faith. So what does this history mean for Fulton, which is not based on a religion matching statute? I'm still working through some of the archival material, and one of the key archives has been closed for the pandemic, so I'm still waiting on that. But here are some of my tentative thoughts. Throughout the history I've been recounting, there were repeated proposals and efforts to establish or improve public agencies to handle child welfare placements. Politicians, child welfare advocates, and others have long recognized that when religious groups dominate child welfare services, that means religious as well as racial minorities have been excluded or disadvantaged. Rather than trying to eliminate or constrain religious providers, often the envisioned solution has been to supplement with public providers. So why hasn't this happened? Certainly money is part of it, but there's also extensive evidence that religious providers, and especially Catholic providers, have rallied against the public provision of services for generations because it would undermine their own funding, control, and power in this space. That observation directly connects to one of the common arguments offered in Fulton and similar cases. Faith-based providers say it would be harmful to exclude them because they do so much for dependent children. And that's true. But a big part of why that's true is that faith-based providers have absorbed a huge portion of the public funding and haven't allowed public agencies to develop as they might have otherwise. Again, these are my current tentative thoughts based on ongoing research. And so I very much look forward to discussing further. Thanks.
Great, thank you so much, Elizabeth. Our third and our final speaker is Frank Cervone, who is the executive director of the Support Center for Child Advocates. Frank is our external speaker, and so we're so grateful that he's taken the time to be with us today.
I assume that's a special breed of speaker, being an external speaker. Otherwise I feel very much at home. It's good to be with friends, and really appreciate the wisdom of Jenny and Elizabeth and the scholarship of Jordan in this particular area. I've been impressed. I'm going to tell you a little story to begin. On March of 2018, March 9th, a reporter from the Philadelphia Inquirer called the Philadelphia Human Services Commissioner, Cynthia Figueroa, and he had a scoop that Catholic Social Services, which was the social services arm of the Roman Catholic Diocese, the Archdiocese of Philadelphia, that they may be discriminating against same-sex couples when recruiting and training potential future foster parents. Now, there were some people, even in that very moment when this story came out, that said something akin to, "What? There's gambling in Casablanca? Shocking." But in point of fact, it was not much known. I've been in the Philadelphia child welfare system quite literally for 30 years. We had heard occasional rumors that there was a form of discrimination, but in point of fact, within CSS, that's Catholic Social Services, within their foster care program, I and others knew of many, many gay and lesbian foster parents. It all came to a head in a different way because of the Oberfeld case and, in a sense, the emergence of legal gay and lesbian marriage. But we'll circle back to that. So the Commissioner Figueroa, would soon learn that CSS was indeed barring same-sex couples from both their foster and their adoption program in violation of the City of Philadelphia's non-discrimination laws. These are long-standing, 30 years plus, prohibitions against discrimination on the basis of identity, applying across the spectrum of engagements by the City of Philadelphia government. This was in no way limited to the Human Services program there. Within days, the commissioner moved to freeze all the new referrals to CSS and began to explore the removal of children from CSS foster homes. CSS and several of its longtime foster parents filed for injunctive relief in the federal court, and a federal battle was on. The case came fairly quickly to the District Court for the Eastern District of Pennsylvania, and the City of Philadelphia was the defendant. My office, the Support Center for Child Advocates, and a gay parents advocacy group called Philadelphia Family Pride joined with the ACLU of Pennsylvania to intervene in the lawsuit. We actually intervened as defendants. In the first instance, of course, everybody thought that was just a little odd. What? You want to be sued? But we did indeed want to posture ourselves with the city on behalf of the kids and on behalf of the gay and lesbian parents who we thought were going to be harmed. And to make a long story short, our motion to intervene was ultimately granted. And the city won, going away at the district court level. It quickly went to the Third Circuit Court of Appeals, and we knew this was soon going to go to the Supreme Court, which it did, and you heard Elizabeth reference. It's pretty interesting that the Third Circuit unanimously affirmed the district court's decision and held that the city did not wrongfully deny CSS. The court did not wrongfully deny CSS's injunction. They found that despite the CSS claim that suspending the contract was out of religious contempt, there was no evidence proving that DHS had acted in a biased or discriminatory manner. They went so far as to say that the continuing positive relationship between the city and CSS in a variety of other forms of human service work, both for kids and for adults, proved that they weren't discriminating against CSS based on religious practice. Then the case, of course, went to the United States Supreme Court and was argued on November 4th, the day after Election Day. We all thought that, of course, Election Day was what everybody would talk about, and we get this listing on November 4th. I'll tell you that your law school colleague, Jeffrey Fisher of the Stanford Law School Supreme Court Litigation Clinic, represented us, that is, child advocates and Philadelphia Family Pride. Neil Katyal represented the City of Philadelphia, and lawyers from the Beckett Fund for Religious Liberty represented CSS. There was also argument from the Justice Department. Folks might be aware the Trump administration's Justice Department came in on the side of CSS, arguing that this form of religious liberty should prevail. One might review. I don't have a ton of experience in the Supreme Court, and with Supreme Court litigation, so a lot of this was new to me. I'm a state court, trial court practitioner and a fundraiser because I'm the director of the agency. But in fact, it was an extraordinary story in many different ways. There were 46 amicus briefs filed in support of the city, 40 amicus briefs filed in support of CSS. Many of them had collaborative groups of amici of 10 and 20 and 30 organizations. It, in some ways, was a battle of titans. On the city side, there was, as Elizabeth suggested, that kind of main argument that the city of Philadelphia permissibly requires parties contracting to perform foster care services on behalf of the city, to comply with the program's terms, including to not exclude suitable foster parents on the basis of their orientation. There's a major constitutional argument in this that you con law professors know well on the question of employment division versus Smith, whether it should be upheld. Smith stands for the proposition of intermediate scrutiny, and there were just as many arguments on the other side that Smith should be overruled. We, for our side, and I do say we sided from a positional perspective entirely with the city of Philadelphia. We argued that discrimination on the basis of identity should be eradicated, and that remains a worthwhile public goal. On behalf of CSS, discrimination on the basis of identity is defensible, was argued, right? And, this is shocking. I'm a progressive. I'm a unbiased, unvarnished, I should say, liberal. I'm full of bias, and I'll wear those on my sleeve. So it was pretty shocking for me that one might take a posture of defending discrimination on the basis of identity at this level of court. But those of us who are familiar with this area of the law know it's hardly the first time that this argument has been brought. Another major argument is that fostering, that act of providing foster care, is itself an expression of faith, both by the agency, that is, in a sense, the personification of the Catholic Church in Philadelphia, in this organizational structure called CSS, right? The church as a ministerial body is expressing its faith, and that the people of that church, like Miss Sharon L. Fulton, this longtime foster parent, a wonderful person who's opened her home to dozens of kids, that it is indeed an expression of her faith that she could foster in the way that the Catholic Church was defining. I'll say that we never got to any real trial on the bounds of faith life as expressed in fostering. This case never went to trial. It's all at this preliminary injunction stage and went all the way to the Supreme Court just on the preliminary injunction. So I'd love to unpack at some point the faith aspects of this. I'm sure we're not going to have so much time today. So I wanted to talk in particular about why we got involved. One can study on your own time, and you'll all be teaching this, at least those of you who teach constitutional law, the case of the Supreme Court on same-sex foster parents and the choice of whether a religious agency should be allowed to deny same-sex married couples the opportunity to foster or adopt. The free exercise issues, the compelled speech issues, and the issues inside Smith on, in a sense, the standard of scrutiny. There's a book to be written on these. What I'd like to talk about just for a minute is what we pursued as a child advocacy office. You heard our introduction. We represent abused and neglected kids in Philadelphia. We think we're at the Support Center for Child Advocates, the largest and oldest volunteer lawyer program for kids in the country focused on abuse, on child abuse and neglect. We're the granddaddy, in a sense, of pro bono work for abused and neglected kids. And we only represent kids, though, in the spirit of the current day. We know that youth can last well into your 20s. And so we have taken on the representation of young adults who had been in the child welfare system. But we really do have as pure as a focus as we can on the needs of kids. And we think those needs include living in a family that wants them and that loves them. By focusing on the child's needs, the practice advanced by Catholic Social Services, we think, really would fail kids in two very important, compelling, really even upsetting ways. First, queer youth and those who are questioning their sexual orientation need a protected and a welcoming place to explore and to grow into their own identities, right? Kids aren't, blocks of wood, and you take them into care, and you shape them with a knife. No, they're just as pliable and formable and needing our respect as any kid that you or I might raise of our own. Young people often enter substitute care because their sexual identity was questioned, was harassed. They experienced harassment and bullying at home and in school. They're judged by their parents and by their peers. That's why they come into care. In foster care, they can meet substitute parents who would try to convert or convince them that how they live their lives and how they think of themselves is wrong. And that's just absurdly upsetting and wrong. The amicus brief of church-state scholars, I thought, captured this. The CSS exemption also increases the risk that LGBT children would be placed in homes that are not accepting of them, or worse. Placing children in family foster homes or under the care of providers who condone discrimination undermines their well-being. That's why we were in it. Second, think about the future of these young people. Many of these young people will someday become gay parents themselves, and some will choose to marry. They need adults in their lives now to show them how to be in relationship and how to parent. We all know that's how we learn to parent. We learn from our parents, good or not. Like all of us who raise children, caregivers of gay kids are called to shape the future adult with our example of love. Having a child welfare system that doesn't discriminate is an important and meaningful symbolic message for the youth who has come for protection and care precisely because of their sexual identity. What a contrary message it would be to tell them that a married couple cannot raise them only because they're gay, or that a youth themselves should consider not marrying or having children. The youth needs to know that we're okay with them being themselves. Child advocates in Philadelphia Family Pride added arguments that all children have a right to feel loved, supported, and comfortable with whomever they are placed, and that the child welfare system needs as large a pool as possible of qualified, licensed foster parents to choose from and to optimize the fit between the child and home. We need to maximize the pool. You can appreciate that the city wasn't necessarily going to go the route of making a major argument about love and respect. And we thought it was important that somebody made that argument in this legal case. Since LGBT youth are overpopulated within the child welfare system, same-sex couples and LGBT foster parents can offer unique sympathy and it's a real empathy, I should say. And LGBT youth may find it particularly helpful to have a foster parent with whom they can identify and whom they can trust. Elizabeth noted, writers have chronicled the historical legacy of racial and ethnic and cultural discrimination in the child welfare system. This system that was built to be good for kids has done grave harm in so many ways. How generations of political and religious leaders and child-serving professionals have made immoral and illegal decisions while ostensibly serving the best interests of children, right? This is my profession. And it's so upsetting to read of the orphan trains, of religious discrimination, of excessive corporal punishment, all by folks who are, in it for the right reason. I'm not even talking about the people who are psychotically in it for the wrong reason, right? These are all folks who came forward and made choices with their lives, with their money, with their futures to take care of kids. And yet they've done harm. So we say, let's not make discrimination on the basis of sexual orientation the next bad choice. Child advocates intervened as a defendant to assert and protect the rights of our child clients to live with caregivers of all identities and backgrounds. We like to say that we affirm the value of all families. We're really proud to have played a role in this case. We hope it's going to be a win. Anybody who knows anything about the United States Supreme Court knows that it's a bit iffy, to say the least. The profile, the composition, as they say, of the Supreme Court does not bode well for us. But we're hopeful, seeking the most inclusive approach possible in order to find loving and stable homes appropriate for them was compelling for us. We hope that this case will bring a ruling that will open more doors to the many children who are looking for stable homes, and show the rest of the country what kind of an inclusive and welcoming place Philadelphia truly is. So thank you.
Great, thank you so much for that. We're now going to transition into the Q&A part of our panel. To the audience out there, please feel free to type your questions or your comments in the chat, and I will do my best to make sure that those get read. I'm not seeing any questions as of yet, although one question did just come in. And this is from Marianne Case at the University of Chicago. And the question is for Frank. And the question is, don't all the very good reasons you're giving why gay kids need support an even stronger argument for the state cutting off all ties with the Catholic agency? After all, the gay prospective foster parents can go to other agencies, but the kids are stuck in the control of the Catholic agency, who itself and whose foster parents do not approve of their actualizing their orientation.
Yeah, we've certainly engaged the question a lot in the community of folks who have been struggling with this case, and in a sense, the choices implicit in it. What we know as well is that there's lots of good people doing human services in the Roman Catholic Church. And we are talking particularly about the Roman Catholic Church. If you were to look to the amicus briefs, you'd see that lots of other religious groups came in on our side. But we're really talking about the Roman Catholic Church as it's embodied here in the U.S. So lots of good human services happening, lots of non-discriminatory service happening. Whether we, your question really suggests, should we associate with an organization that thinks this way? That's a really compelling question. It's we see similar versions of it in race relations these days, and in other areas in which discrimination is, in a sense, the predicate. I'm standing on the side of hoping that they will come along. I'm a liberal Catholic. There are indeed a few of us in the world, and we think that the Roman Catholic Church will someday catch up to the mission it was set out to do, and we're really living in just an aberrant moment these days. That aberration probably has been lasting for a couple hundred years, but in the grand order of time, I'm patiently awaiting for the true message to come forward.
Great, and we have a question that just came in for Elizabeth, and this involves the religion matching statutes, the ones that remain on the books, and the question is, do they tend to require matching in placement and adoption, or do they tend to suggest or allow discretionary consideration of religion and matching?
They tend to be, or perhaps exclusively are, discretionary now. And so it's difficult to know exactly how heavily they weigh, since religion can still be a factor in foster care and adoption placements. And there are so many other factors in the mix, it might be obscured how much a particular judge is weighing religion in a particular case. But historically, many of the statutes could have been read as discretionary as well. And part of why there was so much litigation is that it seemed like religion was trumping, or clearly was trumping, the other factors in many states, especially Massachusetts and New York.
Great. And then, Jenny, I'll prompt a question for your research. Near the end of the presentation, You mentioned that a surprising number of parents, I think you said 20% of parents, are going to decide to stick with homeschooling after the pandemic. And I'm wondering if there was any research that or preliminary insight into why that might be the case or what the reasons were.
Thanks. So it's really interesting. This was just one interview I've been interviewing folks all over the country for this project for a while now. And this was an interview of someone here in Nashville. And so this was respect to Metro Nashville public schools, sort of big metropolitan area. And as I mentioned, predominantly minority, predominantly low income public school population. And I was stunned when the school board member said, well, we're really thinking that after the pandemic, we're expecting as many as 20% of Metro Nashville public school students. So I should note here, Metro Nashville public schools are now almost all, but right now they're all virtual. There has been very little in-person, unlike other metropolitan areas, and others, particularly other areas in Tennessee. Nashville public schools have almost entirely been virtual since March. Briefly brought back younger children earlier in the fall, but that didn't last long. So I was stunned to find out that they are expecting a significant percentage, a significant minority of students to continue with online learning even afterwards. And I said, what do you think is going on? And she said, that it was hard. They didn't know. She didn't know. Some thought that children who are in difficult social situations, children who felt school was unsafe, not parents not eager to send their children back to school. I know I've read other commentaries suggesting that other commentators saying that perhaps African American students may be some African American parents think their children are doing better in virtual school rather than going to their predominantly white schools. I'm not sure sort of what to expect. I do feel that throughout a lot of popular commentary on homeschooling tends to overestimate its diversity. It's not clear to me kind of what's going to happen, but it's an interesting question. I mean, it certainly does suggest that even if it's not 20%, even if it's 5%, that is a lot of children, and suggests to me that we really have to stop thinking about online school as an afterthought and more of sort of a educational option that needs to be of reasonable quality. Thanks for the question.
Great. And this is a question that came in for the panel in general. And the question is, have you had experience with creationist homeschoolers? And do you have any opinions on whether their homeschooling meets the state standards?
So I can take that one. So I guess if by creationist homeschools, so until relatively recently, most science materials for homeschoolers were creationist. It was for actually one complaint that you would have from homeschoolers who were non-religious that it was very difficult to buy science materials that explicitly addressed evolution, because even material resources designed for homeschoolers that weren't explicitly creationist were trying not to alienate that market. And so they would just leave out a lot of topics, a lot of subjects, try to dance around the issue. Sort of, well, this is a subject we're not going to get into. In terms of state standards, I mean, state standards tend to be fairly low. So I'm not aware of any cases in which parents were charged with educational neglect for failing to teach their children about evolution. I think to the extent that there has been kind of a control on it, it has come with university requirements. So there have been sort of interesting questions about state university requirements, sort of what kind of high school background needs to whether certain creationist texts are acceptable for acceptance into a state university program, sort of high school texts. Sort of issues with taking sort of the SAT 2 biology exam. That's kind of where less sort of state standards, which again tend to be quite murky and relatively low. And when you've seen some tension with families who want to teach their children creation, it tends to come with high school and college admissions. I hope that answers the question, at least from my take.
Any other panelists want to respond? If not, I'll go on to the next question. Okay, so this next question, it's for Frank, and it's from Nancy Polikoff. Thank you to those in the chat that told me to hit the refresh button to get the names on the comments. But the question is, I wonder if Frank could comment on the fact that by not pulling Catholic Charities' contract as a community umbrella agency, the city of Philadelphia has left Catholic Charities in charge of case management when an LGBT parent has a child removed and placed in foster care. Research among low-income Black mothers has shown that those who identify as lesbian or bisexual are 4 times more likely to lose custody of their children to the state. I find it shocking that an agency that believes same-sex couples are not fit to be adoptive parents is in charge of providing services to LGBT parents whose children are removed and who want to get them back.
It's not a dimension that has been studied much at all in Philadelphia or in many places. It's a very, very credible concern. I can tell you, we haven't seen that kind of discrimination, in a sense, on the street. But you have to imagine that in a sense that it's out there. Certainly not confined to CSS. Point of fact, with kind of a broader incidence of discrimination on the basis of identity in the public marketplace, in the public arena. It's certainly possible that we're going to see this in a sense, in the relationships, professional relationships, and the relationships of so-called resource parents or foster parents with the families of origin, the birth parents. CSS has been pretty explicit in their representations to the court, and I think it's consistent with the experience of folks who have worked with them that as an organization, they have not been, in a sense, blatantly discriminatory on the basis of sexual identity per se. Now, but again, we are really talking about at the organizational level. I'd be the last person to defend that organization or any other for what they've done inside the confines, in a sense, of this case and the types of children's lives that have been touched by it. I can tell you, having worked inside the organization in my early life, you heard my bio at the beginning. I worked at St. Gabriel System. It's a program of CSS, and gay folks work there. We worked with gay kids. It was just not even noticed. In that sense, I was actually pretty surprised when we heard in 2018 that the practices were happening as they were. So I hear you. I think it's a pretty complex set of phenomenon when working with persons and their identities. And there's a lot of good people doing the work, notwithstanding what the leadership of that organization, in a sense, the local leadership in particular, has been driving. Philadelphia is a place that, if you're at all familiar with church politics, it's run by some archbishop, and this case came up under the administration of Archbishop Charles Chaput, and he's a really bright guy and an arch conservative. I mean, among the most conservative thinkers in the Roman Catholic Church. So it came as no surprise to me that when the fight was to be had, they would take the aggressive position they did. I would suggest to you that his, in a sense, style of politics on sexual identity is not shared even broadly within the organization, and certainly not in the Philadelphia Catholic community.
Great. We have a quick follow-up question from Cynthia Godso, which is geared to the panel. Can anyone comment on the tensions some advocates had in the Fulton case who wanted to support non-discriminatory placement policies but are concerned about the removal of children in the first place, which is very racialized, often punishes poverty, etc.
It's one of the leading edge topics in the child welfare community today, at least among progressive thinkers in the child welfare community. And Philadelphia is, in some ways, the worst case example. As the earlier question suggested, we remove kids at a far higher rate than most communities, and we have a predominantly we're a majority minority city population, but a way disproportionate population when it comes to removal factors. So there is clearly race and racism in the mix, and yet, it's a community, it's an organization and a system that's been run by pretty progressive people for a long time, and so it's a real tough nut to crack. Lots of us are in that conversation, and we haven't figured it out yet.
I would just add, and building on the follow-up comment I see in the chat about the relevance of poverty as well, I think this is another area where looking historically can really help us understand how we came to a lot of the problems we have now. Because there were so many financial incentives for religious groups and other private child welfare agencies to continue intervening in families and keeping children longer than maybe was necessary or in the children's best interest because of the funding that they were getting and because of the control and power that gave them in their communities. So often, if we look historically, it's quite clear that what was happening wasn't for the best interest of children. And this system we have now has just been built up over generations, where maybe if we were to start from scratch, we would do a lot of things quite differently.
Great. And our last question that I think we'll have time for, since we're already at 58 past, is from Kyle Velty, which is shifting gears a bit, but it's about the bans on conversion therapy for minors, and specifically the recent 11th Circuit case that blocked the enforcement of the Florida ordinances involving conversion therapy bans. And the question is whether any panelists have thoughts about the outcome of those sorts of cases and what they'll be and why.
Well, I can tell you, in the child welfare world, the practice is almost exclusively repudiated. Right, that it even got to this level of appeal is pretty extraordinary. It's very sadly pursued in these kind of little pockets, really hard to find. I can tell you from I've looked occasionally just out of curiosity as to who's doing it, conversion therapy, and thankfully there doesn't appear to be much of it. And there just aren't many proponents of it. But at the same time, it's a little like child trafficking. It's hard to find. We know it's out there, and by way of outcome, we ought to stomp it out and beat it to death.
Great. So now we are at the top of the hour, which I believe is this goes until 4. Is that right? So if we could just give our panelists a clap in the chat and thank them for their insightful comments. And thank you all for coming. And I hope that you enjoyed the presentation and the rest of the AALS conference.